Hi, my name is Zainab and I'm giving a breach of client confidentiality case analysis and recommendations to the senior partners Shirley Ballard and Anton Beck. So today we're talking about a solicitor, Rachel, who lost a client file in the tube post-court, but the file was recovered intact, however, having been viewed by third parties, which raises substantial client confidentiality issues. In the backdrop of these facts, this presentation seeks to consciously do the following: assess the regulatory breach, recommend best steps forward, analyze liability and potential client actions, advice on reputation management. The breach by Rachel Rogers. It is evident from the available facts that Rachel is the individual who had possession of the file at the material time when it got lost. This has not been refuted, and as such, it is perfectly in order to make a conclusion that indeed Rachel has breached her regulatory responsibility by failing to keep the client's file and information therein confidential. Breach by the firm would be as it is already established that the file truly got lost and was unlawfully pursued by unauthorized people. There is no doubt that the firm is vicariously liable for the aforementioned breach, given the fact that Rachel is an agent of the firm. The firm is obligated to ensure its employees are compliant. And the next steps would be conduct internal probe, notify the client, report to SRA, enhance existing policies and training. I'll go through them one by one. So for conduct internal probe, the firm should document the incident and conduct a thorough internal review of the existing procedures and policies. Notify the client would be, it is important to let the client know of the incident since it is in their best interest and it would be with the principles of good conduct. Report to SRA. A threat that poses a risk to the client's interests should be reported to SRA as recommended in their notifications and reporting guidelines. Enhance existing policies. Ensure that regulatory compliance policies are updated to address any existing shortcomings. Training would be the last one. Train all staff of file handling and data protection. The training should be mandatory and continuing. The potential courses of action discussed herein are the most likely to be pursued by client depending on their preference. So lodge protestation with ombudsman. The client may elect to submit a protestation note with a legal ombudsman who has jurisdiction over such matters. File complaint to SRA. This is another potential avenue for recourse that the client may decide to pursue since it is common, especially where breaches cause significant harm. This has been addressed by common law jurisprudence, for instance, in Swain v. Lord Society 1983 1 AC 598, where it was averred that legal professionals are held to a higher standard of care regarding client information. Where possible court proceedings, this is a possible course of action for Susie Socks, especially if the breach will cause reputational harm or financial damage. The client is at liberty to institute tort or contractual proceedings before a court of competent jurisdiction. Liability and consequences. Legal practice is a profession that is characterized by the fiduciary responsibility of practitioners to their clients, and this must be maintained at all times to avoid exploitation, unnecessary harm to the said clients. In Hickman v. Taylor 1945 AC 304, the court observed that the firms bear vicarious liability for the actions of their employees during the course of their employment. Now, Rachel's liability, being a qualified and a licensed legal practitioner, Rachel is directly obligated by the statute, code of conduct, and her oath to maintain her client's confidentiality at all times unless prescribed otherwise by the law. She is liable and likely to face regulators' punitive measures and also internal disciplinary actions if necessary. Firm's liability would be the SRA code of conduct imposes a strict liability on firms, particularly on issues pertaining to safeguarding of clients' confidentiality. Hence, the firm is also liable for Rachel's shortcomings. The consequences of the breach addressed herein include, but are not limited to, regulatory fines, reputational damage, and mandatory system review. Reputational management. When the reputation of the firm is at risk, the business and financial health such a firm is also at risk, and this situation should be avoided. However, when this happens, firms should be in a position to institute corrective measures in a timely fashion and also address potential risk of these reoccurring. This can be done via various ways depending on the specific circumstances of each case. So one of the ways is transparent communication. The firm should ensure that flow of information on this particular incident flows unperturbed to and from all parties involved. Public relations strategy. If necessary, the firm should consider disseminating info, acknowledging the breach, and ultimately outlining the corrective measures it's undertaking. Adapt long-term mitigation circumstances. These may include audit and compliance reviews, technology adoption, file access monitoring, and enhanced security protocols. To summarize this presentation to you guys today, it has been established that indeed Rachel and the firm have committed substantial breach of the regulatory requirements set out in the Code of Conduct, as well as precedents laid down under common law. Attorney-client privilege is a fundamental tenet of legal practice, and failure to comply with the set rules will always result in adverse consequences. It is therefore the prerogative of every firm, the individual solicitor, to ensure that the set rules and regulations are adhered to whenever infringed. Implement corrective measures to ensure the best interest of its clients and avoid the resulting of repercussions. Thank you for listening to my case analysis and recommendations for the breach of client confidentiality, and I hope to see you again soon. Shirley Ballard and Anton Deck.